Article 13. Mitigating circumstances. The following are mitigating circumstances. 1. Those mentioned in the preceding chapter, when all the requisites necessary to justify or exempt from criminal liability in the respective cases are not attendant. 2. That the offender is under 18 years of age or over 70 years. In the case of minor, he shall be proceeded against in accordance with the provision of Article 80. 3. That the offender had no intention to commit so grave a wrong as that committed. 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. 5. That the act was committed in the immediate vindication of grave offense to the one committing the felony, his spouse, ascendants, or relatives by affinity within the same degree. 6. That of having acted upon an impulse of powerful as natural to have produced passion or obfuscation. 7. That the offender have voluntarily surrendered himself to the person in authority or his agent, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect which those restrict his means of action, defense, or communication with his fellow beings. 9. Such illness of the offender as would diminish and exercise of the will power of the offender without, however, depriving him of the consecution of his act. 10. And finally, any other circumstances of the similar nature and analogous to those above mentioned.